seconds. Good morning, this is CJ Holmes, founder of Homeowners for Justice, your host today for Weekdays Live. A new Monday, a new week, more judges getting mad, so that works for me. And the fact of the matter is, homeowners must fight back, and that's our goal for today. How do we get this really under our belts so that as a nation we can keep people in their homes and stop these fraudulent foreclosures? So we're going to talk about the corruption. We've got some documentation that came in over the weekend for corruption. The whistleblowers, oh my goodness, whole bunch of stuff. I want to review that, and these things that I'm going to be showing you today are just still PDF files. I will do my best to upload them and probably link them to the homepage so you can find them right there, handy. And we're going to be inviting Linda on the show in a minute. She's really excellent when it comes to knowing so much about the underpinnings of the securitization, the audits, what is going on. She has so many connections, and I really like to have her share that with us. So first I want to talk about SEC enforcement. The bottom line is the judges are getting mad because the SEC, and truly this has just really irritated me too, and that is it seems as if these executives are using these corporations as their personal armor, and they direct and commit all this fraud via the organization, and then they have to do this big settlement and pay out, but they don't pay. It's the organization that pays. And so they go home with their billions. And this is starting to make the judges mad. It's making us mad. And we need to push this with anyone that we know to get more people mad, and to get our local officials mad, and our local attorney general mad, and the judges upset with this whole way of escaping penalty, because that's really what they're doing. So I wanted to show you this. The first one is about the Citigroup. This happens to be a settlement in 2011, and it's it's $285 million. But you'll notice that they sold over $1 billion. So again, this is called a cheat tax, a fraud tax. We're going to just rake in the billions. We're going to take it to ourselves personally. And if there's any tax or penalties to be paid, we'll just make the company pay it. Who cares if the company goes banko? Who cares? The executives don't care. Of course, all the people working there lose their jobs, but they don't seem to care about that either. And so as we scroll down, we see, a litany of people and companies that have been charged. Now here, the firm agreed to pay a record penalty of $550 million. This is in 2010, and this was Goldman Sachs. ICP Asset Managements. Here they charged the president, who did agree to pay something. But notice here, $153 million JP Morgan Securities. You don't think Damone settled anything, do ya? Think not. And that is the point. As we scroll down, we'll notice that a few of these are more current. Like here's one, Commonwealth Bank Shares. SEC charged 3 former bank execs in Virginia for understating millions of dollars in losses and masking the true health of the bank's loan portfolio. That came down in January. It doesn't say what kind of penalties or how that's resolved. Perhaps it's not resolved yet. At least Mozilla did agree to some penalties and being barred from being an officer or director. And then as we scroll down, we're going to see more and more, look at this. This is, and others. This is just a litany of fraud. This is what caused the investors to lose their money, what the homeowners are losing their homes, because the whole thing was a toxic fraud scheme from the beginning. This is the point. They're going to just milk everybody in the system, everybody, government, IRS, buyers, borrowers, investors, insurance companies, you name it. They're going to defraud it, and then they're going to get away with it. And this is why the judges are getting mad. So here, this is a summary page, which I'll have linked, of course, in the comment sections after the show. The number of entities and individuals charged, 154. But then a number of individuals who've received officer and director bars, only 36. Frankly, considering that there's more than one executive of each company, if this number, 154, of the entities and individuals, it should be 300. It should be 1,000. Charge every one of them. Make them all pay. Claw back all the things, the money that they earned, plus penalties. Come on, that's what fraud is. Fraud is treble damages. Let's never forget that. So these guys are still skating. And I don't care if this is $1 billion in penalties. Disgorgement, that means clawback. That means pay back. Only 756 million? Come on. These guys did, it's estimated, hundreds of billions, if not $1 trillion or more dollars worth of these collateralized debt obligations. And this is truly an outrage, and I'm really pleased that some of these judges are getting angry. So let's take a look at that article. Oh, and I've highlighted, here's the title. As mad as hell, fury as judges nix no-fault Wall Street deals. Now the judges are really upset, and that first one that we talked about on the SEC page at Citigroup, that happens to be the first judge. It happens to be at the end of the article. I'm going to scroll down right there so that you can see it. So the first judge to kick up a storm was Manhattan federal judge Jed Rakoff in 2011. He rejected the SEC's $285 million pact with Citigroup over the sale of soured mortgage-backed securities. And he said in 2011 that this allowed Citi, all the executives, the company, everything, to neither admit nor deny wrongdoing, which is what they say. Oh, sure, we'll sign this, but, we're not going to say that we did anything wrong. You can't force us to do that. And it came at the expense of the shareholders and the truth. He sees the truth. And unfortunately, the SEC, the OCC, the federal agencies, they are not about to get down to the truth, and we have to understand that. And this is what we're going to be talking about today. And also, how can we partner with these judges? How can we expand this information? Send this article to every judge that you know. Send it to every attorney. Let's get the people in our counties aware that this is what is going on, because as you know, and as I know, everybody's just working double hard and totally focused on what they're doing, and they don't have the luxury of just, searching Google to see, are any judges mad at the banks? So let's help them with this research. That's I view it as one of my tasks and duties, is to collect these links that people send to me and to broadcast this information, to put it back out in the public consciousness so that everyone watching can pass this out, and we can really start to magnify the effort of this one article. It's a very good article. I highlighted here what I'd like to just read. The latest example of judicial frustration came this week when Manhattan federal judge Sidney Stein raised concerns about a $590 million settlement agreed to by, guess who? Citigroup. Here we go again. To settle charges it deceived shareholders about its toxic mortgage holdings. They've created loans designed to fail, violating every truth in lending law in the country. They foisted those off onto borrowers. They fraudulently induced the borrowers to use these loans and buy property using them. And then they've treated them like deadbeats, as if it was their fault. And this is the point. The shareholders' suit did name the former CEO Chuck Prince and senior advisor Robert Rubin, but only the bank and not the executives paid to settle the case. Until we get the executives doing a perp walk, 3 hots and a cot, Even the millions of dollars, trust me, that's just money, and they're just going to get it reimbursed. They've got deals. You know this. They've got golden deals all over the place, parachutes. So it's not just the money. We need to get these guys really charged, disbarred, keep them out of the industry, bar them from being an officer and a director. But we also need to claw back. And if we can connect them directly to the fraud, we need to get them in prison. Because when these people think, oh, I'm going to go to prison, then they're going to think again before they start trying to cheat the public. So I wanted to talk about that. And then I want to talk about the document of the fraud. What we have right now is documentation of this process. And this is a really cute little cartoon. I just had to show it. This is the mortgage modification department. And notice how the person, the Spock, single point of contact, sitting at the desk says, sorry, I haven't gotten your documents. Can you please resend them? And truly, this is how we all feel after you've sent them 20 times. And that is, they come out of the faxes and they go straight into the shredder. And now we know that's true. That's what they're doing. It's truly amazing. I'm going to welcome Linda on the show, and then I'm going to start talking about these things that have been documented and discovered. Hi, Linda. This is CJ.
Good morning, CJ. How are you?
Oh, fine. Here, I'm going to turn up the phone just a little bit. And the first thing I want to talk about is this document, the chasm between the words and deeds. And this is documentation by an organization that actually has surveyed all these people, and they have come up with these statistics. And the Spock, single point of contact, that's what Spock is. It's not working. And that the counselors, they're interviewing the people that are working with others for loan modifications. And basically, for example, on the single point of contact, all of these counselors reported that over 70% of the banks that provided Spocks were sometimes, rarely, or never accessible. So here's the divide. And Linda, I want you to talk about this with me. And that is, the rules come down from on high. You know, some agency, the OCC, the U.S. Department of Justice, somebody says the banks are going to do this. California passes a law, Homeowner Bill of Rights, and it says the banks are supposed to do stuff, but then they don't. And this is one of the major problems, is the enforcement. What do you do when they just keep doing what they're doing? So here's the dual tracking. This is dual tracking after it's illegal to dual track. And 60% of the counselors report that B of A, Citibank, JP Morgan Chase, Wells Fargo still dual track, sometimes, always, or often. And this
always.
This, of course, should have been stopped months ago. So here we go. They have, I've said this before, you've heard me say this, we've talked about this together. And what can we do about this other than getting this news out more and more and more to the media? And that is, they violated the OCC cease and desist orders in 2011. These same guys, same banks, here you go. They violated the U.S. District Court consent judgments of 2012. They're still violating those orders, plus the Homeowner Bill of Rights in California. And this, of course, is nationwide. So what do we do, Linda? Do you have any other ideas?
Well, it's an interesting point made on page 4, right before the topic key findings. It names the 5 big banks as being part of the national mortgage settlement. Just to show you that they can organize to get something done. In that particular agreement that they signed, all those who were foreclosed upon in a certain time period were allowed to receive benefits. And a discovery I made tied in quite well with this when I was trying to help people process the OCC and the National Mortgage Settlement. They may have gotten a judgment in the time frame, but the sale didn't take place, and the actual transfer of the property didn't take place till after that time period. And just in Palm Beach County alone, I could name you probably thousands where the banks of incidences where the banks were aware of that time frame and the specifications, and were canceling the sales and rescheduling them till after the time frame to alleviate their accountability. So if they could join together and knew what was coming then, and have a plan of action, there's no excuse why they can't follow. So they're great laws, but no regulatory agency. That had to be part of it, and it wasn't. So our only option is report to the AGs, report to the file a complaint with Rust Management, with the mortgage settlement branch, the National Mortgage Settlement. Call them, file a complaint. It's fun. They don't want to give you any names or anywhere to write, but put them on notice, and then make a statement, an affidavit, if you will, of what happened when you talk to these agencies, and file it with the OCC, with your AG, with every AG if need be. Copy them all on it. That's the only thing that's going to get action from what I see.
Now, Linda, let me just reiterate for the people in case they've missed it, because Linda and I have talked about this before. And the fact, what Linda is saying is that these banks knew rules were coming down, like the independent foreclosure review was going to cover foreclosures done from January 1, 2009 to December 31st, 2010, right?
Mm-hmm. Yes, and then the National Mortgage Settlement extended that time frame till 2011 if the foreclosure happened during that period. Well, judgment is, you get a judgment of foreclosure, one would think that means you were foreclosed upon.
And so what the banks were doing, and you saw patterns of this, you saw signs of a pattern of behavior where the banks would ensure they would cancel a foreclosure and restart so that would not be included in the review.
This does not happen in Florida. The banks don't come in and cancel the sale for no reason. And our particular court, Palm Beach County Court, had enacted a rule that in order to cancel the sale, they had to go through an motion and appearance. So now it appears on the docket, where otherwise it would not have appeared on the docket. So they were giving themselves firm proof that, the certificate wasn't issued then, the sale didn't happen then, it happened later on. The first, and this was not just one time there was cancellation, this was 3-4 times on each different mortgage. And what they were doing the first time, they told the judge, we're here because we've got to check our documentation in the light of new discoveries. Second, third, fourth times, they didn't even explain. We just were rescheduling the sale. Then cancel it, go out and reschedule it for 3-4 months down the road until they were well into out of the time frame. And think of the thousands they saved just in my county alone. I couldn't understand what they were doing when they did it, but now it makes perfect sense.
Right. What this is the point. Hindsight is 2020, and these bankers are in the middle. They are actually in the center of all the action and activity, so they're going to know what's coming down the pike. They're talking to the OCC. In fact, now, articles have talked about the banks telling the OCC the independent foreclosure review wasn't going to work. But the OCC went ahead with that. Of course, the banks have worked hard to make sure it didn't work. And now, at the end, at the end of last year, I remember, Linda, you and I were talking, how are we going to get people to sign up for the independent foreclosure review before the timeline's over, the deadline at December 31st. And then it comes out the first week of January that the banks said to the OCC, we told you it wouldn't work. And they completely dropped the program after spending $1 billion on it, and we're going to talk about the documentation. Now we've got documentation of what that program looked like, and it is not pretty. This is truly another thing that document and verification of the fact that the banks are planning this. They've worked hard to stop every effort to coerce them to be accurate and honest, and it's a manipulation. I have to call it a criminal conspiracy. What do you say, Linda?
Oh, absolutely. And I think you're now referring to the document about the BOA whistleblower.
Yeah, yeah.
Okay, now I'd like to point out something in that one in particular also because when I was fighting for these homeowners and I call up to verify that they were on the program, and I so often, I knew they qualified. I knew that, for one thing, the master servicer had substituted in a um, subservicer to try and deny accountability. So when I would give the information, oh no, these people don't qualify, they're not on the list, I asked to speak to the manager, who would only identify himself as John, and I did a round robin with him. Well, what's your process if somebody wants to contest? We don't have a process. Well, I know for a fact, I'm a housing counselor, I'm an auditor, I know that these people qualify. I have all the proof here. You must have something or something. No, we don't. Okay, well, I'm documenting this conversation with you and I'm reporting it to the proper authorities. So, and then I look at the BOA whistleblower and see that I was talking to a guy who was earning between $350 and $650 an hour, and he couldn't give me any way to file a complaint or to question that his documentation might have been wrong, and knew absolutely nothing.
Well, that was the point. And I think that's what this whistleblower reveal how B of A defrauded homeowners and paid for a cover-up, all with the help of regulators. This is what it documents. Just read the titles. Overwhelming evidence, the chapter titles. Overwhelming evidence of widespread systematic abuses by Bank of America. Why the cover-up happened. And they hired Promontory, which evidently is a company with zero experience, zero knowledge, and zero management, because absentee management produced confusion, waste, and unreliable results. Why it happened, how the cover-up worked, how the cover-up happened, and further cover-ups by B of A, including document fabrication. So, that... Yeah, this is the point, and why the OCC overlooked independent reviewer Promontory's $1 billion Keystone Cops Act, and then some appendices. I wanted to actually show a couple of episodes in this because it's just pretty amazing, some of the stories that they quote. Now, this is. I believe these, well, here, let's start with the introduction. This is the scandal that the book describes began not in late 2010 when robo-signing became national news. And let's never forget that robo-signing is forged documents. They forge the signatures, and then they have false notarizations that notarize those signatures as if they were the correct person, and if that person really was had the correct authority and did the correct actions to make that document valid. And so we know that robo-signing is a dismissive term that we must always fix. We need to constantly hammer that robo-signing is forgery. It's just a dismissive term for forgery, and we have fraud penalties. We have, you're going to go to prison kind of penalties for forgery and monetary damages. And this is written by the naked capitalism folks, and they talk about this, how they became involved in this, and how bad it really was. One of the stories I wanted to jump to is down the way a little bit. This was they talk about digging. I'm here on page 76 in the review, and well, let's just back up. Let me talk about this first one.
Yeah, I know there's so much to here.
It's really tough to say, which one shall we focus on? Well, the first thing is the concept of digging, and you'll see that here's the word used, digging. And digging means, if you're a reviewer, if you're the person hired to do this reviewer, you are not supposed to go do any other research other than just answer the question, yes, no. And don't go digging for more facts and trying to find problems with it. And so, for example, in this case, the reviewer was definitely criticized for digging. And she says, yes, I was the only person in that group that had a lot of bankruptcy knowledge. So if I brought something up, or if I would just say, how would this get addressed? Because this is what I found, they would say, don't. Don't what? Don't address it. It's not going to get addressed. You have to stick to your questions. So even from I would call this low level cutting off of the research and the discovery process. So she learned very quickly what her place was to just stick with it. And although reviewer B learned to toe the line, he described how other reviewers were not as compliant. Reviewer E was one of them. I had one where the person got a modification, and when they said, and I'm going to read, it says, they capitalized everything. What that means is the servicer had put all of the fees and the back due payments re-put them into the loan. They recapitalized the loan with that. And then the servicer gave the borrower a HAMP trial loan mod. And then the borrower said, I don't want HAMP, I have a mod. So they took both mods out of the system, but kept everything, all the loans and back due fees, capitalized into the loan. And so another HAMP trial mod, they capitalized everything. The borrower said, I don't want HAMP, I have a mod. So what do? They kept it out. They would do this over and over. And so the same fees, the same back due payments, they would keep adding again and again. So the third mod finally stuck, but now the guy's payment is $250 higher because they keep recapitalizing everything until he signs. And then this is what they did. They took the file away from that reviewer because that reviewer was digging too deep. And here's another one. And this one is going to ring true with thousands of owners. You got to listen up and you got to pass this out. Hit the blogs, hit the Facebook pages, and this is on page 76. Make a note. Reviewer B discussed the digging of another reviewer. One person was this way, went to one of the managers, says, I think the last week that we were here said, hey, I have a problem with this test. And the manager rolls his eyes and says, I know, like every other test. And she's also the same person that found a borrower that made like a $20,000 payment, and the whole payment just disappeared from the system. The borrower did not get the money back.
Accounts, right?
It was never applied to any fees or any payments. It was just gone. And that was escalated to, someone else that was probably going to just throw it away. Yeah, they pulled the loan out of that reviewer's queue, and she would repeatedly ask, hey, did anybody hear about that loan? And they would repeatedly tell the reviewers to stop digging. And so where did that money go, Linda?
To the holding companies. They're the ones who keep the suspension accounts, and they're collecting all the monies because, it's easier to hide there. Their accounting system is a little bit different. It gets put through the Federal Register. So we could check their tax records all we want. It wouldn't show up for the bank.
Now,
I personally have some people who this happened to, and they were in good faith, paid the modification, and then were denied, so they had to reapply, and all the payments they made were completely nullified. So having been delinquent in the bank's eyes now for 2 years, she was disqualified, even though she faithfully paid her modification.
And all of those payments, you think, went to that suspense account?
Oh, yes. It has to go into a suspense account, number one. But the federal rules about suspense accounts is they either have to be applied or returned within 30 days, and they're forgetting about that. They take out from the law only what they want. We can put it in a suspense account, then we can play with it, do these things to the homeowners.
Oh my! And are you actually referring or reflecting some of this dual bookkeeping that you were talking about last week?
Yes.
And so tell us again,
And shadow banking too comes in there. Terms we've not heard of before.
And the shadow banking, how would you describe that?
Just what it says. It's banking going on in the shadows that's not illuminated to the general public. Very covert.
And see, I want to read this other story that just reflects exactly what you just shared, because they documented this from the reviewer standpoint. This happens to be now, guys, on page 95 of the same whistleblower report on Bank of America foreclosure review. So here's a particular case. It was a foreclosure. Not only was a foreclosure, but it went to the state attorney and then it was reversed and they rescinded it. So what happened was there's the logs. You know, the reviewers would be reading these logs of what interaction the borrower, the person owner trying to get a loan modification, was going through with the servicer. They're reading these logs that were done in the past. And so she's reading the log, you know, of the call, and this lady happened to call in, and I'm not exaggerating. She probably had her Outlook set to pop up every 2 weeks or 10 days, and she would call in religiously, even though they would tell her, the servicer would tell the owner, you know, it's going to take 30 days, you don't have to call back. She would still call back and kept calling back. And there would be notes that she'd call back and hear, it's still in review, it's still in review, it's in underwriting for review, you know, all that standard stuff. And then finally it comes to this. I think it was December 17th, if I remember right. She had called in and she's asking what's the status of her modification. And the person says, ma'am, you can't get a modification. It's an REO property. And REO, of course, means real estate owned, which means the bank had foreclosed on it. And so, you know, the people are going, what? And the reviewer is said, that's exactly what's an REO property. Now the reviewer is stating, now I read all of these comments in chronological order. I started at the bottom, read them straight up, and I did the exact same thing you just did. I'm like, what? Where did I miss this? She's calling in, and now keep in mind, she's been making trial payments with auto debit from the checking account. They have been debiting her account for all these payments. And the girl says, ma'am, your property went to foreclosure sale in September. Now they had taken her September, October, November, and December payment after they'd foreclosed.
Right.
How could they have done a foreclosure when she's still living there? And so, and so this is the point. She ended up filing bankruptcy to keep from being evicted. And so, you know, this is another thing. They have all these separate, they talk about the different tests, A test, B test, C test, D test. And so when I catch this case in G test, because, you know, they had done the C's and before they'd done G and everything, you know, before, oh, they'll catch it in G. So a lot of times the reviewers would let things go or be told to let things go, and they would hope it would be caught in the next test. And I don't understand, says the reviewer. So I go to my manager and I say to him, this is a case that was done as a one and done, but it's not a one and done. And so the manager says, well, let me review it and I'll get back to you. So he comes to me and says, okay, there's no harm done to her because ultimately she got her modification. And I said, well, wait a minute. The C reviewer missed this. It went to quality control. Quality control missed it. Promontory reviews it. And their notation is borrower is currently in a modification. Well, because when they reversed it, they put her in a permanent mod then. So by the time the promontory reads it, they're seeing all they saw was she's in a permanent mod. How can you say there's no harm? And of course, she had to hire a bankruptcy attorney to keep the house. I mean, the whole thing is just a nightmare, as anyone trying to get a loan mod recognizes. And the reviewers recognize this, but no owners got paid. I mean, that is the point. It is just complete, a complete corruption.
Well, I think this emphasizes, especially in California, you're going to have to watch the posted sales. You're going to have to keep up on the modification and not take anybody's word as truth.
Well, and besides, like we just read in that, it really didn't matter that here you have some person who's actually, she's got the reminder. She's calling in every 10 days or 2 weeks.
Right.
And they're lying to her. They foreclose in September and they're telling her in October, November, until finally in December. Before that, they're just saying, you know, it's in review. It's in review. Don't worry about it. It's in review. This is truly an outrage. And the fact is, I believe, Linda, what you're saying is actually right. You've seen the patterns of the banks intentionally manipulating the system for their benefit.
Yes.
Oh, I'm sorry. I just have to read this one more thing to you guys. You'll want to read this. I believe this is now on page. Oh yeah, this is on page 88 of the whistleblower report on B of A. Another controversy discussed widely amongst the Tampa Bay reviewers, was the missing fee notification to North Carolina borrowers during foreclosures. In October 2012, the matrices for the tests involving fees were updated, and it included new material on state fees. One major new item was that North Carolina law has a strict policy on fees, that the fee must be charged to the borrower within 30 days of being rendered, and the borrower had to be notified in writing of the fee within 45 days of being charged. And there's some minor exceptions to that. Many reviewers on the fee test were unable to find any such fee notification letters. Even a more savvy reviewer, who thought that some of his colleagues might not have been as diligent as they could have been about looking, said on average only 10 to 20% of the letters were in the system. Even a reviewer who was tasked to other tests mentioned them. He went looking for them in his North Carolina files and found none. However, one reviewer who did find them pointed to a suspicious pattern of many of the letters turning up in the files after the reviewers found out about the new law. So the reviewer states, this didn't come down until October or November. And then the question is, what do you mean, this come down? It wasn't included in reviews? The reviewer says, yeah, we didn't know about this rule. It was a new rule that nobody knew about. Well, I had a file that happened to be North Carolina that I was in with someone when this new rule came out. So I had to go back in and look for it. Nothing there. So I just let it sit for a minute and moved on to another file. About 2 weeks later, there were 50 of those letters that magically appeared in the system. And this was very common. So the questioner says, so you're saying that while the review was on, Bank of America was fixing the documents and uploading stuff in the system. And the reviewer says they weren't there, and then magically, when the law was brought to light, they showed up. They started appearing in the thousands. And of course, there's no proof that they got mailed. It's just a one-page document that has a fee on it. And the reviewer continues, when I went back to the reviewer, or the article continues, that he might have simply not looked thoroughly enough the first time, this is the reviewer's reply. There was only one place in the system for documents like this to be, which was in the iPortal in Portcom Docs. When I was first looking at the borrower records I mentioned to you, there were only 10 documents there, no fee notification letters at all. When I went back into the file, there were 20, and the new ones were all North Carolina fee letters. And I saw other letters appearing in borrower files. You'd see a document with a title, say, inspection fees, but if you clicked on it, it was a blank page. I'd come back later, and it would be completed with a date and a fee amount. The reviewer also stated that a colleague working in a different building claimed to be on a team of roughly 300 people that was altering documents, changing servicing notes, backdated fees, and reclassifying fees so they would look as if they had been charged to investors rather than borrowers. They go on to say they've not gotten confirmation, but they point out that virtually every borrower file had reclassified fees, well beyond the level that can be attributed to a correction of mistakes. So I think that's no real surprise to you, right, Linda?
Oh, no. And I think the issues brought out in this report will apply for Bank of America and California reconveyance for the California homeowners. I think these are the issues we can look for changes in documentation and what we have to flag down to stop the foreclosure sales.
How do you recommend we do that? Do you have any ideas?
Well, just itemize all the issues, which I haven't begun yet, quite honestly, because I just reviewed this in completion this morning. But itemize all the things that they use to create the documents, the methods, and so forth, and have a checklist of what to watch for, and that's what you're going to have to monitor until. And when we find this, when we have the documents, and you see a difference in a document that you were mailed and a document they're providing at your request, then you can just point to this report.
Right, right. In other words, we could actually make this report as part of the exhibits.
Right, as part of your defense, absolutely.
Whether the exhibits are being sent to the media or to your district attorney and your supervisors or in court, I would highly recommend that this exhibit be included, because the fact is it points to patterns. This is a pattern of behavior. They just manufacture documents. And Linda and I have talked a lot about this.
How they did it. Yeah, it shows how they did it. That's important. I think last week, the young woman you had on who got her mortgage loan statement in detail, and there was unaccountable fees on her, fees that didn't make sense. Well, now this whistleblower statement lets us know why they were there and how they did it.
Right, right. And also the fact that if and when anybody else, an independent reviewer, actually looks at the notes of that case and the documents, they see how they've cheated. They've just lied, cheated, steal the property, and if a new rule comes to light, then the banks are going to just forge documents to fix it.
Do you notice in the time frame of them processing the review, and you look at what this whistleblower's explanation of how they fixed it, that department was up and running. Obviously, they'd already done things like this before.
That's a very good point. How can you get a department to start forging documents willy-nilly without some prior training? That's a very good point. They probably pulled them from some other document forging effort.
No comment. But
Okay, I want to talk quickly about the Federal Housing Finance Agency, FHFA, who now has oversight of Fannie and Freddie. And this is for immediate release of March 27, 2013. And they've announced today, that Fannie and Freddie will offer new simplified loan mod initiative to minimize losses and help troubled borrowers avoid foreclosure. It's not going to start until July 1st. Borrowers have to be at least 90 days delinquent. And then there's some other rules we're going to scroll down here and look at. So what do you think about this, Linda?
Well, the one good thing I can see coming out of this is that if you're contacted shortly after July 1st with this new program, even though they didn't let you know before that, it means that your loan was purchased by Fannie or Freddie. And what has happened, a lot of people who never even knew their loans went to Fannie or Freddie when there was a default, there might have been a buyback provision that the originator or the servicer had to buy back that loan. So our loan could have been invested in Fannie or Freddie and bought back, and we never even knew it. This, I think, would be especially good for the WAMU to Chase people who were financed between that black hole time period of September 2007 till receivership of WAMU, and they don't know where their loans are. I think personally a lot of these went to Freddie for a loan commitment that had been made, or to Trump's. Now, if you get notification from this program, and you were a WAMU to Chase, in that instance you could identify that it was pooled in one of Freddie or Fannie's accounts. So I think in that way it's good. How much this is really going to be carried out, I don't know. It remains to be seen. I don't put trust anymore.
Well, why? How could you? How can any thinking person give any government program trying to regulate any kind of bank whatsoever in any way, shape, or form? Because it feels as if pretty much they're just completely run amok. And we already know that Fannie and Freddie started the the suspiciously forged assignments and trustee substitutions. I mean, that their attorneys, in fact, are the ones that started doing this years and years ago. And so when they lead the way in corruption, It's hard to imagine anything that comes out actually working. Now, I did want to point out, I've got here on the screen the that this program is supposed to remove administrative barriers associated with document collection and servicer evaluation. It will begin July 1st, 2013 and end August 1st, 2015. The loan must be owned or guaranteed by Fannie or Freddie. Owners must be 90 days to 24 months delinquent. So now here again, they're saying, Linda, that to
Cut
get
a lot of people out. Yeah.
well to get the
Small
there's
handful compared to the foreclosure numbers.
well here's the point. It, here we go again. They're now telling us that the only ones that qualify for this have to be delinquent. They have to stop making their loan payments. So let's say you're not in delinquent yet. But obviously, this is what, April? So you got April, May, June, July. So if you stopped making May, you didn't pay May, June, or July, you'd be 90 days delinquent. And so then you could qualify for this loan mod. So they're now officially putting in writing that the people have to default to qualify for this program.
And then guess what? When you default, you qualify for extra fees tacked onto your principal.
Penalties and fees that they capitalize into the loan. So in the end, the loan modification is going to probably, just like all the other HAMP and other loans that we've seen, almost without exception, they ramp up the fees. They may cut some off, but in the end, the net is higher than it used to be. And the payments are sometimes higher than what the people are already paying. It's just truly an outrage. In other words, my humble opinion, the fix is worse than the cure is worse than the disease. I don't know, maybe not.
Well, like I said, the only thing I can see of a real benefit is it'll help you to identify, provided you haven't already gone through, a long period of time and your home was already sold, then it would have been bought back. Maybe the bought back clause would have applied, buyback clause would have applied. But if you're currently in, it's possible you could identify into what pool that your Fannie or Freddie has put it. It's the only benefit I really see.
Now, so basically, here's the other point. If the loan must be, homeowners must be 90 days to 24 months delinquent. So what if you're 22 months delinquent right now? And so by the time this July 1 rolls around, you're going to be 25 months delinquent.
So it may have been repurchased and you don't qualify under the Fannie and Freddie and you'll never know.
And the first lien has to be at least 12 months old. So in other words, this will only work for loans that were taken out over a year ago. And the loan to value ratio has to be at least equal to or greater than 80%. Mm-hmm. But it doesn't say, and if you've had a loan mod twice before, you don't count. Oh my goodness. They come up with these rules.
Any exceptions when you look at it and in light of what's really going on and the whole picture, it's nothing.
And here's another one. How does this initiative differ from other ones? Well, a key difference is that borrowers will not be required to document their hardship or financial situation, but will be able to accept the streamlined modification offer by simply making, here we go again, the trial period payments and agreeing to the terms of the modification. Now, tell me again, Linda, if the borrower makes the trial period payments, where do those payments go?
Suspension accounts. I've seen it. It's not just hearsay. I've seen it. I've seen the paperwork.
So the people are given choices between a rock and a hard place. They either continue to make their loan payments, or if they've already defaulted, they try to work for this loan modification. But to do that, you have to pay more money out with absolutely no way to guarantee that those payments ever will be applied to your payment. Is that correct?
Yeah, it's highly likely.
So even those people that make these trial loan mods, and we've already talked about how it's now been documented, and you and I both have personal experiences with owners that have been making their trial payments. One of the worst cases I know of here in Sonoma County, it just breaks my heart, and there's nothing yet I can do for her. And that is, she made loan modifications for payments for 18 months. The bank took every one of them, foreclosed on a Friday, took the house, just foreclosed on her, and on Monday sent her another statement to pay another modification payment. And they've booted her out. She's lost every effort she's tried. She had to leave the house. It's just been awful. And so the fact is, if she was able, or like we've already talked about, people will send in a debt validation demand. Tell me where the payments went. Send me a payment. And then what you get back doesn't match what you've done. That's pretty consistent, isn't it?
Yes. Well, I became aware of it early on in one of my clients who was making the modification payments, and then when she got a payoff price because she had a private investor who would, refinance for her, none of her payments were credited. In fact, it was higher than what it should have been. Again, the fees were put back on the principal.
Now, okay. So we know that this is going to happen to almost everybody. So what can they do about it? What happens? How does a person take the next step? What should they do? I mean, they scream in the bedroom. Now what?
Well, I think we have to find out all the documents, and like you and I are trying to do, get together the strategies that work and present it to the homeowners, and I'll do this en masse. That's the only thing I can see that will work.
So really, what I'm hearing is somehow oh geez, see, this is the divide and conquer. They have chopped us up into little pieces, and we have different servicers, we have different lenders, we have different stages of defaulting. Some are current, some are in limbo land, they haven't paid, nothing's happened. Some are trying to get loan modifications in there. Others are just saying, I don't even know what to do. It's like deer in the headlights. And some are starting to be foreclosed, and some people are fighting back. Some file lawsuits, some file bankruptcy, some do what I'm talking about, the OCC letter, which seems to have some effect, at least initially, for a while.
That's right. That ends too.
Right. In the end, that ends.
Yeah, I think that's the greatest challenge that everybody faces, is everyone's at different processes. So if we can use everybody's information and sort of do, as you've done, a spreadsheet of where you are in the process according to your state or your lender, and then the things to look for. I mean, generally the things that they're doing are consistent with every bank. It's just different names, that's all.
You mean the way they're cheating and the way they're
and the documents they do to support it, and they're stepping in, and the courts just accept it because they're the right documents. It doesn't matter who signed them or if it was done in the correct protocol, or does anyone check if they're really the beneficiary?
Right. On the face, they look legal or legitimate on the face of the document, like we've talked about in analyzing our recorded docs.
In lieu of having a broader solution, the beginning steps would be to file complaints about your particular documents or what has happened to you or not happened to you in the independent review. If you haven't gotten a little card saying that you're going to be called, and notice that it says a check will be issued, or you will be contacted in 4 to 8 weeks. They really left a big loophole for themselves. So you don't get a check, you get a letter saying, well, we're reviewing. So that may mean that none of us are going to get any restitution, but we might get an acknowledgement that they still have your file under advisement. Be prepared. But keep filing with the proper agencies, the OCC, your state AG. Go over the documents for suspicious signatures and the fees that are involved. Pursue that. Pursue that and build build yourself a case against the banks.
Right. Right. And what you just were referring to, that letter that's coming in the mail, that is the next level, if you will, of this independent foreclosure review, right? The whistleblower follow-up. The document.
It's a folded over postcard from Rust Management, so don't accidentally throw it away.
It's a postcard?
It's like a folded over postcard. Like when you overdraft your bank account, you get a notification that's folded over. That's how it comes.
Okay, so they have worked very, very hard. I'm sure they have paid big bucks to some marketer to find out how to make sure most people will throw the notification away.
Correct.
Let's start there. Let's just have these people think it's trash. Let's make it look like trash. So they'll throw it in the can, and we'll never hear from them again. So this is the bank's next step, with under evidently the approval of the OCC, in that independent foreclosure review, which was the whistleblower document that we just looked at, that was exposing all of the fraud and corruption and intentional deception in the independent foreclosure review process. So now they're going to send out a card. Half the people are going to throw it out, or they're sending it to the house that was foreclosed, which now has, 2 or 3 different owners in it since they lost the house. And so they'll just throw it out because it won't be forwarded. It'd be long past forwarding. And then it says that document evidently states that in the next 4 to 6 weeks, or 4 to 8 weeks, the person who was wrongfully foreclosed or had a foreclosure in 09 and 10 is going to get something, a letter. Mm-hmm. Okay, and they don't say they're going to get money. They don't say what they're going to get.
And even if you call the number, they don't designate how much you may qualify for.
Okay, so you know what? Here's what I swear they're doing. I swear they sent out, however many millions of these they had. 2 million? Do we even know how many foreclosures in that time period? So they send out, let's say 2 million. And so they send out these letters. And then I swear they're probably only going to count those that call back. The next letter in 4 to 8 weeks, they're going to send something out and says, if you want to talk to somebody, if you want some money, you have to call. And so then out of that, let's say 300,000 people call. And so then they'll have whatever little pot of money that they can crank down from the OCC to disperse, and they'll just divide by the people that call back. I swear it will have nothing to do with anything other than what's best for the banks.
Right, and all the while, Rust Management is logging up more hours and getting paid more.
And who is this firm?
They're the ones that are doing the independent. They're the guys like the chief one for the independent foreclosure review.
Right, they're racking up billions of bucks. The homeowners have been shoved out of the house and lose all their equity, their home, their livelihood. They've broken the economy. Now the people are under the bridge in tents, and it truly is a devastation. And it's just crime run amok. That's how I view it. It's really crime run amok, and we're trying our best to bring this to everyone's attention. Give us, each one of us, tools to fight back. Ideas of how we can proceed. And truly, anybody that's watching, if you have any other ideas or you have a contact that you think could help bring this information to the national attention. On the plus side, I do want to share that this report that came out, the very first one, I'm going to bring it back up on the screen, that we looked at today, the chasm between the words and deeds. This report, this actually got some attention in our local newspaper this morning. I might add that our local paper pretty much is not interested in anything I say or do. They don't want to hear it. They don't want to see. They don't, foreclosures are deadbeat homeowners. They don't want to hear the truth. And it's not for lack of trying, but I think that is the way the whole media is. They just really don't, they're so caught into the myth that it's all about these homeowners, and they haven't paid it, and so they should lose the home. Nothing about the whole toxic fraud scheme and what the banks have intentionally done to destroy this country. And to have something show up in our paper today about that was actually surprising. I think we might be starting to get some sway, and that's all we can do. We just have to keep pushing. It's like swinging back and forth. You keep pumping to get a little higher, and we keep pumping to get a little higher. Let's keep pushing that swing, guys, and let's pass these links out. Let's make them viral. Let's talk about them. Let's write letters to the editor about them, and let's see if we can't, in each of our local communities, create more of a stir. Because as more communities get stirred up, we can get more national attention. So I think that's about it. Lynn, anything else you can share with us, encouragement or guidance, before we shut down the show today?
Tomorrow is a new day, and there's a rainbow after every storm.
That's true. That's true. And the silver lining is all the people that lost their homes, if we can connect with them, that's the power. We'll get a power, because every one of them is in the same boat. They've lost their house. They lost their jobs. It wasn't their fault. They were playing by the rules. They were told to default to get a loan mod. Their homes were stolen. This is the community we need to go after. This is our 12 million person niche market. So let's go get our niche. Thanks, Linda. We so appreciate you joining us today.
Thank you.
As usual, everything you say is so valuable. I just really appreciate your support. And so, guys, that's it for today. And tomorrow is a new day, just like Linda said. And tomorrow we're going to talk about more, what can we do to really bring this home and protect ourselves.
Like my father and mother before me. They taught me to fight for my civil rights. But it's always the same old story. The rich reign supreme while the poor can but dream. Under Labour or Liberal or Tory. And I say, bugger the bankers and politicians. Bugger the bureaucrats too. Bugger the buggers who make up the rules. And if you're one of them, bugger you. And if you're one of them, bugger
The system is bent and the money's all spent.
We're measured from every direction.
The workers get taxed while the wealthy relax.
with nary a moment's reflection. Where there's brass, there's muck, and they don't give an arse, 'cause they're programmed against insurrection. And I say, bugger the bankers and politicians, bugger the bureaucrats too, bugger the buggers who make up the rules. And if you're one of them, bugger you. And if you're one of them, bugger you. Now all you good people with passion to vent, don't give up the struggle for justice. But I've done my time on the protesters' line, and these days I show my dissent by loitering with